All right, good morning, everyone. This is the Martin County Code Enforcement Magistrate hearing for June 19th, 2024. If you'll all rise, join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, great. Be seated, please. Thank you. We're going to begin with a case that's on the top of the second page. It's a Thomas Glass case. It's a fine reduction hearing, and it's case number 100042691. So a 2010 case. Okay. All right. And Ms. Bradley, you're going to testify if you raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Whenever you're ready, you can begin, and then we'll hear from the respondent. I'll call you up as soon as Ms. Bradley is through presenting and identifying the case.
Okay. My name is Rachel Spradley, and I've been sworn in. I'm the Nuisance Abatement Coordinator for Martin County. This case concerns the property located at 1769 Northwest Sunset Boulevard, Jensen, in Martin County, Florida. On February 16, 2011, an order finding violation was issued by the Code Enforcement Magistrate to Thomas F. Glass for Section 67201B, nuisance declared trash, etc., General Ordinances, Martin County Code, Section 21.121.1 glazing, General Ordinances, Martin County Code, and Section 21.111 protective treatment, General Ordinances, Martin County Code. So Exhibit 1 is the property appraiser showing that Mr. Glass is the property owner.
Okay.
Exhibit 2 is the original recorded order that was placed on the property.
All right.
Compliance was required by March 9th, 2011. On September 20th, 2022, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $1,263,600 plus costs in the amount of $575. Staff has determined that a lien reduction is warranted. The respondent was responsible for the violation, and they brought the property into compliance and have offered to pay $21,625 to resolve the outstanding fines which have accrued. In addition, staff has considered the $216,250 assessed value for the property. So Mr. Glass is paying 10% of the total property value for his reduction.
All right.
And Exhibit 3 is the affidavit of compliance with accrued fines. And then Exhibit 4 is Mr. Glass's reduction request.
Okay.
And that
All right.
concludes my
All
testimony.
right. Mr. Glass, come on up to the podium, if you will. All right, and if you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God? All right, and I'm going to ask you to take your hat off. Thank you. All right, so I've got a fine reduction stipulation and agreed recommended order. That's your signature on the stipulation, is it? Okay. And it requires you to pay $21,625 to the county. It is an agreed recommended order, meaning that ultimately the county commission has to approve it. And so what will occur is if I approve it, and I'm thinking that I am, it goes to the county commission for final approval, and you'll have to then perhaps even appear. I don't know whether these go in consent or, okay. All right, so they go, once I approve them, they go into the consent agenda for commission approval. So do you understand that part? All right. Any questions of me?
No, sir. Just briefly on my behalf, on the original hearing, I was working over in Puerto Rico, and I had no availability to be able to come back to the States to attend the hearing. I tried explaining that to Ms. Zazo, who was the compliance or the code enforcement officer at the time.
Yes.
And there were modifications made to the property as far as trash, debris. The glazing was repaired. The only thing that was not, which was outstanding to date, was the soffit that needed to be repaired. And the debris and inoperable vehicles that were in the yard, one was a welding truck, which I'm a welder by trade. And what they're considering trash and debris was actually material that I used for, at the time I was building buggies, airboats, I'd help people out, different things, barbecue grills just for side money. And so it really wasn't trash or debris, and I organized the yard. I had a dumpster dropped off. I even got cited for having the dumpster on the yard when I was cleaning up, but I know I owe. I didn't realize that. I mean, I'm Martin County resident since second grade at St. Anne's.
Yep.
Worked around here at the nuclear powerhouse, the Roosevelt Bridge, and I would have never have let this go as long as it had, knowing that fines were being accrued to any extent. I mean, I pay my bills. I'm a working, class citizen. I'm doing my best to try and get by, but, I kind of didn't know anything that I owed anything until I went to take out a loan to put a roof on my house. And that's when I was notified that there was an outstanding code violation on my property. And that was when I reached out to code enforcement to rectify it and move forward. And, I understand I do owe, and I would like to, anything I could do or you could do, I would really, $20,000 is still a lot of money.
Sure.
My wife has got, a lot of back issues. She got degenerative spine disease, and we take care of my mother-in-law who has dementia. And it's just $20,000 is a lot to come out of pocket. I know I agreed to it, but that was the only way that we could even move forward. I tried talking. I came to the last month's county commissioners meeting, and Doug Smith is actually over my district.
Sure.
I tried reaching out to Doug. This is over a year and a half. I've been, trying to reach. I spoke to Rachel and John Colano quite a few times, and the only way that we could even get to where we are today was to agree on the 10%.
Okay.
But if you,
All right.
you can
No,
find any leniency,
well,
I would greatly appreciate it.
There would have to be what the law calls some mitigating factor, and I'm not hearing it. I mean, the fact that you weren't aware of it
What-
isn't a legal
and-
basis.
I'm sorry, I didn't mean to interrupt you.
Well, it isn't a legal basis. So let me just ask the county, you obviously have negotiated this amount.
That is correct.
All right, and the county commission, when they look at these, have arrived at this 10% calculation is what they expect to see.
I understand.
So, all right,
Also, in some of the records, it did show to where, that the debris had been cleaned, not totally removed. I'd have to go back on all this stuff.
Does-
I mean, I have the printouts of when somebody was by the house, and it was almost 10 years that somebody had came by to reassess it. 2020, they were there. 2022 was when it was finalized. 2010 was the original
okay,
issue. But,
It-
the glazing was repaired, but like I said, I was working out of state, out of country, actually, and it was my wife, and I guess if they were making notices, they said that, the debris was cleaned, the glazing was fixed on the side, but she couldn't tell on the back side because the shutter was down, but it had also been repaired. The only thing that wasn't was the soffit.
Okay. Let me ask the county, do you have record of partial compliance?
Yes, sir.
You do not? You do? Okay, and did you take that into consideration as you negotiated this?
Figured into the fine. So we stop them as we comply them,
Okay?
and then, because there would have been $300 a day.
So
So we would have stopped it as we found them with however many days it was out of compliance.
the
for.
1.2 million took that into
Yes, sir.
consideration? Okay, all right. If you don't have anything else to tell me, and based upon your signature, I'm going to go ahead and approve the stipulation and agreed recommended order as submitted. And I hear you as far as your personal situation, but I think there's not a legal basis to consider it further. So I'm going to go ahead and approve this.
Timmy, thank you.
Okay, all right. Good luck. I hope this enables you to go forward.
Thank you very much. Have a great day.
Yes, sir, you too. All right.
Okay. I'm mixing them up with somebody else.
All right, just to tidy things up on that case, I'm going to include into the evidence Exhibits 1 through 4 that were presented by the county, just for the record. All right, now, let me just make sure, I know we were waiting, Mr. Cassidy, who are you?
Yeah, Mr. Kennedy.
Okay, you're both here, okay.
We have you sitting out there in the hallway.
Okay, well, I'm glad you're here.
I guess what my brother was, he's inside.
Okay, all right. Well, let's take Mr. Counselor's, Officer Counselor's cases first, and one of these is your case, so,
Yes,
all right. And are you ready to go with the Cassidy case?
yes.
Oh, good, okay, great. All right, so if you'll raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. And let's see, this is case ENF 2024-050215-01. The respondents are Sean T. Cassidy and Mark L. Cassidy III. And Officer Counselor, this is a violation case, gentlemen, so what we're going to do is hear from the county first. If they make what the law calls a prima facie case, meaning everything that they've presented is correct and accurate, and then they will then be able to go forward. I will then call you up to the podium, swear you in, and then you can make your presentation, okay?
Can I give him some information he didn't have yesterday?
I suppose you could. Do you-
When I took pictures of an open driveway, and I've got pictures of it fenced in.
Okay, well, you can present those, and that'll help.
Not now?
Not now. Let's hear from the county, and then we'll go forward. Okay, all right.
Ronnie, just a point of information, this is a
Yes.
repeat violation case.
This is let me find your recommended order. This is a repeat violation case. Okay, so what that means is that you're subject to being fined from the day that the violation was discovered. And again, that's assuming that the evidence presented makes that case. So let's hear from Officer Counselor, and then we'll go forward, okay?
Okay. Hi, my name is Chris Counsell. I've been sworn in. I'm a co-compliance investigator for Martin County. This case is a repeat violation case. The respondents, Sean T. Cassidy, Mark L. Cassidy III, are present. This case concerns the property at 3240 Southeast Dominica Terrace in Stuart, Florida, which is located within Martin County. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Sean T. Cassidy and Mark L. Cassidy III, which is County's Exhibit 1. The property was previously brought before the Martin County Code Enforcement Magistrate on August 12, 2020. A stipulation agreement was signed, and the owners agreed to correct the violations of 67.201B, nuisance declared trash and debris, General Ordinances, Martin County, and Section 3.420, which is the M1 Industrial District Code from the Land Development Regulations, on or before December 31st, 2020. On December 31st, 2020, an inspection was conducted. All violations were corrected. A copy of the original order from 2020 and the affidavit of compliance are County's Exhibits 2 and 3. So this is the stipulation agreement from 2020 for the violations that they were cited for, with the agreed upon compliance dated December 31st, signed by the magistrate. And
Okay, so it was trash, abandoned vehicle, and the zoning violation, the M1 industrial district.
And that code basically states that in an industrial zoning, any aspects of the business must be conducted within the confines of the structure located at the business.
Okay.
And Exhibit 3 is the affidavit of compliance signed by the officer complying the violations as of December 31st. On May 15, 2024, I inspected the property. At the time, I observed the property again in violation of trash and debris, and materials for the operation of the business were being stored outside. At the time I photographed the property, the photographs accurately show what I saw then and are marked as County's Exhibits 4, 5, 6, 7, 8, 9, and 10. So these were all dated May 15th.
All right, looking at 4, tell me what I'm seeing there.
Okay. Exhibit 4 is basically the front of the property. This is the location. I got materials stacked right here in the driveway. Exhibit 5 is as I drive down the road. I basically got materials and parts stored outside.
Okay.
Exhibit 6, just a side view, just showing that there's pallets of materials. They're parts either for vehicles or the forklift that are just out front. Exhibit 7, at one point when we first started the case, we were concerned about the vehicles in the right-of-way. We pulled that code because the code didn't apply. That was basically the initial complaint, is the vehicles parked in the right-of-way, but the code that we had on the case, that was used for previous case, we pulled that violation because it didn't apply to just, basically it's their employees parking in the right-of-way. The code that we had cited, that's in the NOV and the NTA, we've pulled that because it didn't apply.
Okay, I understand.
Okay. Exhibit 8 is basically showing the front yard. Exhibit 10 is just, basically they just have, there's just materials that should be either stored behind the building or screened from view that are basically in plain view from the street. And Exhibit 10 is just, like I said, that included the vehicles. Based upon the investigation and previous history of the property, I issued a repeat notice of violation to Sean T. Cassidy and Mark L. Cassidy III on May 16, 2024, marked as County Exhibit 11. This is the notice of repeat violation. In a notice, I cited the following Martin County Code, Section 61201B, nuisance declared trash and debris. What was included in the initial letter was the code of 91.33, abandoned vehicles in right-of-way. We've since removed that code. And then the third code was Section 3.420, M1 Industrial District Land Development Regulations, Martin County Code, which basically says operations must be conducted within the confines of the building.
Okay.
In the notice of repeat violation, the respondents were informed to comply with all violations immediately, and also informed of the need to contact Martin County Code Enforcement upon doing so. A notice of hearing was also issued by certified mail on May 16, 2024, and it's marked as County Exhibit 12. Being that it's a repeat violation, they immediately get a notice to hearing for today's hearing, June 19th at 9 a.m., signed by me, which at the time included all three codes.
All right.
The return receipt was not received, so on June 7, 2024, I posted the property. A photo of the post and the affidavit of posting are marked as County Exhibits 13 and 14. 13 is just a picture I visited the property. I actually hand-delivered. So my affidavit of posting is a affidavit hand delivery. Also on June 7, 2025, I met with the property owners, Mark and Sean. I inspected the property with them, and the property was still in violation for trash and debris, unsightly materials, and products from the business being stored outside. At the time I photographed the property, the photographs accurately show what I saw then on June 7th, and our county exhibits 15, 16, 17, 18, and 19.
All right, looking at 15, what am I seeing there?
This is basically still the vehicles in the front. Exhibit 16 is basically the materials that are stored to the front right corner of the building. I just got miscellaneous materials that are just stored outside, parts. June 7th is just an up-close view of the parts I'm referring to. It's just, I assume it's parts for either vehicles that they're repairing or forklift repair, but there's just, all this stuff is stored outside out front. The gas tanks, all this material. Exhibit 18 is basically the one part in question the most where they really need to work on either screening it or removing it, is all this material in the picture.
Okay, what's the story with the boat?
I don't have an issue with the boat. I mean,
It's not illegal for them to...
it's not illegal to have it. It does take up quite a bit of their lot, which limits their space to have other materials. We discussed that. So, yeah, there's no question, there's no problem with the boat. It's not a violation for the boat to be there, it just itself hinders them from having other storage space on the lot for the business. Exhibit 19 is the other side of the building, just showing materials stored outside. And basically, I mean, I got a worker here working on the ice boxes outside. This is the type of stuff that's supposed to be all that stuff is supposed to be done inside the building per the industrial code. Section 20 is just the front of the property. 21 is just the vehicles that no longer apply. That's just another shot of the front corner. Oh, I'm sorry. Go back to, that's a different set of dates. So those pictures were all from June 7th. I went to the property again for the day before inspection on June 18th and saw that cited violations progress had been made, but there were still areas of the property that still needed to be cleaned up. At the time I photographed the property, the photographs accurately show what I saw then, which would be my final exhibits of Exhibit 20, 21, 22, and 23. So these are as of yesterday. So a lot of material has been removed. So the left side of the building was good. The vehicles were still there. But the big area that was still in question yesterday was still that section at the front right corner of the building. They still have materials stored with an up-close shot of basically all this stuff either has to be screened from view or stored back behind the building, which is still, that's what basically still left the property in violation.
All right.
I request that all the county's exhibits be received into evidence. Based upon the testimony and the evidence, I request that the respondents Sean T. Cassidy, Mark L. Cassidy be found as repeat violators and be ordered to comply with the cited provisions of the Martin County Code immediately, and be required to pay a fine in the amount of $250 a day per violation per day for the date starting of May 17th after they received my notice. So the fine should start as of May 17, 2024, and for every day the violation continues after. The counties incur the cost of $575 conducting this investigation, and I request that all counties' evidence be, the county be reimbursed this amount at the conclusion of today's hearing.
Okay, are you both going to speak, or? All right, come on up if you will. And if you'll,
Right side,
Okay, well, you need to show him, not
fenced
me.
off. I'm just showing you first.
Okay.
and left side, gone. Okay?
Oop, here's the deed.
Supposed to be
All right,
Good to the deputy.
Mr. Cassidy,
The,
Stay on the podium.
you'll stand at the podium because we need to get you on the mic. If
it's
you'll
been a
raise your
while
right.
since I've done this.
Yeah, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
And your full name, sir,
Mark Lawrence Cassidy III.
and your address.
Uh,
Business address is fine.
Business 3240 Southeast Dominica Terrace, Stewart, Florida, 34997.
And what is your relationship to the business that's there?
I'm the president owner.
Okay. All right. So you've heard the county make its presentation and present its evidence.
Eh?
Any objection to any of that
No, as of,
Okay. as of
as
yesterday?
of yesterday, there's no trucks out there,
Okay. So
totally.
let me
truck-
just put it on the record. Without objection, I'm going to accept into evidence the county's exhibits 1 through 23. That means we can use them to consider. So, and I see that you have brought now a couple of photos as
Right.
well. Is that
It's
correct?
fenced off the way they asked me to.
All right, let me ask you about the photos that I'm looking at. Let's see. Looks like there's two of them, right?
One's the right driveway, and one's left,
All right,
or north and, or east and west.
okay.
The big one's the east driveway.
That's the east area?
That's the main driveway going in and out.
Okay, I'm going to
Deli-
mark
that's
that
deliveries.
one as your exhibit number 1. And the other one I'll mark as exhibit number 2.
They're both 6 foot.
All right, so what am I looking at in this photo?
There's nothing there now.
Nothing on the
You're looking at a fence.
driveway apron?
You're looking at, yeah, the driveway apron going in, and it's now got a fence so you can't see anything.
All right.
Go on. As per Rachel Spradley,
Is it
told me if I put a 6-foot-high fence up, gate covering, that anything in back of that doesn't exist.
well, okay.
both sides.
I know
I know.
what she's saying is that, of
Now, the
course,
junk that's out there in the driveway,
yes.
that changes week to week, because what we're doing is, we're bringing the stuff forward. I'm selling the business.
Is that what we're looking at in respondents two?
Yeah, that's on the right-hand side, or the west driveway.
Okay,
Every week that changes out, we take it on over and trash it. Where the boat is, was 60 feet of, in your words, debris or whatever, junk, gone.
that you've now removed from the
Oh,
site?
yeah. And there's a lot more going.
Okay,
The new owners don't want anything there. Zero.
all right.
And I can't say it's a blame.
Okay, all right.
The trucks out front, the 2 trucks that were out front, the one in the driveway on the west side is licensed and insured and was missing a drive shaft until last night. And the 2 trucks that were there were not abandoned vehicles. I own them.
Okay, let me see if I can find those. Are either of those vehicles in Exhibit 15?
They've been sold about 4 times. Yeah, but like I said, we removed the code 21, we removed the code 91.
That was not in violation, the parking
we're-
on the right-of-way.
We're not concerned with the vehicles at this time, for this case.
I called him all day yesterday, no response, for him to come over and take a look and see at the fences.
Okay, all right. So
Probably busy.
let me ask Officer Counselor, looking at Respondents Exhibits 1 and 2, if everything that we see on Exhibits 1 and 2 is correct, would the violation remain or no?
Well, the issue is basically what he stated is that they've put 2 gates over the driveway, so when the business is closed, the gates are closed and you don't see it. But during
I'm
normal,
open and closed all day long if you'd like.
well, that's the issue, is
Doesn't matter
that
to me.
during normal business hours, those gates tend to be open, which gives anything on the lot
Did you
is,
hear what I just said?
I understand, sir.
Okay.
Wait a minute, hang on. It's got to come through me and not,
Right.
I don't want you
So
to talk.
I understand what is, yes, he put front gates up. So basically, when the gates are closed, the materials are not visible from the road.
Okay,
But what he also testified is the materials still exist on the property. You just can't see them when the gates are closed. But that does,
For Rachel,
the other thing that I'm seeing here is it looks to me like it's a fabric material that's maybe applied.
it was approved by the Martin County Building Department.
Okay, and
Marco.
that's fine, but if you have a gate there, do you then have to remove the fabric to get
No,
into the gate?
travels through the gate.
It does, okay. All right, so that's helpful. All right,
Your Honor, might I be heard on this for just a point?
sure,
As far as what the
Yes, sir.
ordinance requires. I think we're into a little bit of semantics here as far as with closure. The actual wording of the ordinance is, all operations shall be conducted and all materials and products shall be stored within the buildings of the plant. All waste materials shall be stored while on the premises in a screened enclosure, which shall be counted as part of the area allowed for occupation. It seems that the intent of the ordinance is that a enclosure be provided inside the property, not the outside gate. Now, the outside gate, if it never opened up, that would be an enclosure, but every time it opens and closes, it's in violation.
Want to put a zigzag in there, so you have to drive around, you can't see anything?
hang on. I'm going to go back, I'm looking at the order, the Exhibit 2. No, it's going to be, looks like it's going to be in an Exhibit 11, which is the notice of repeat violation. On page 2. And Mr. Tui, if you'll direct me to what you're looking at here.
On the 32420A, subsection 2A.
2A, all operations shall be conducted and all materials and products shall be stored within the buildings of the plant. All waste materials shall be stored while on the premises in a screened enclosure, which shall be counted as part of the area allowed for occupation by buildings and structures. So my recollection of that is that that's more like a dumpster enclosure, is what that waste material storage
It could be a
area.
dumpster, but waste is fairly broadly defined in the ordinance.
Okay, but I mean, I think that was the intent, if I recall, of that, not that it just be strewn around. So, all right, you do have a unique situation, though, because you have large pieces of equipment and machinery, the ice machines and that sort of thing, which are somewhat unique to your business.
and we have spoken in the past, there would be no issue with the ice machines that are in the pictures that are being not used, like the ones that say ice on it.
Yes?
If that's all that was across the front of the property, the county would be okay with that. It's just all the other materials that's in between. It's the parts, it's the scrap metal, it's all the other issues, so.
Okay.
We've never had an issue with the actual ice boxes. It's just all the stuff that ends up on pallets in between those ice boxes.
And up until yesterday, the photos that I've seen actually do show all of that. Okay. I think I've heard enough to find a repeat violation, and I'm going to accept, unless you've got any objection, I'm going to
No
accept
objection,
these
Your Honor.
into evidence, Exhibits 1 and 2 for the respondent. It looks to me like you're well on your way to complying, and you may
Way more than that.
be in compliance at this point, and that's my hope for you.
Rachel told me to put anything that I could on trailers, so I bought two 56-foot trailers and put most of the ice boxes on them.
Okay. All right.
Bit of work.
Based on your representations and testimony and the exhibits and the fact that you are apparently making an effort here, I'm going to reduce the amount of the fine. There is going to be a fine component because it was clear that from the get-go, there was a
Shouldn't have been there.
violation. All right, and it does run from May 17th until it's brought into compliance. I'm going to reduce the fine to $100 per day. That's for both violations. That's going to be a hefty fine, but it'll be probably a $3,000 fine.
Are you saying $100 per violation? or-
No,
Okay.
just $100 per day.
Okay.
Regardless of which violation it still remains. So $100 per day. Of course, I'm going to order compliance immediately, and hopefully, when they go out there, maybe even later today, they'll find that that's been taken care of. I am going to further award costs in the amount of $575 to be paid to the county at the conclusion of the hearing. So let me take a look. I've got a draft order, but let me just look at it. Are you going to be out there today, do you think?
I can be. My afternoon's clear.
If that's the case, I'm going to go ahead, I may have to interlineate some of this order. We'll try and have Officer Counselor bring you a copy of it. But right now, that's where it stands. Thank you. Good luck.
Thank you.
All right. I'll take a look at that in a bit.
Do I pay now or?
No, actually, let me sign the order, and then you'll get a copy of it this afternoon, and then you can act accordingly, okay?
Okay,
All right.
thank you.
Yes, sir.
Thanks.
This afternoon, sorry.
Give me full well.
Yeah, I got your message this morning. Okay.
All right, yes, sir. Scorpio's case, right?
Yes, sir.
All right, this is case ENF 2023 110551-01. Is it Scorpio's Summer Season LLC? Is that correct?
It's my mom's property.
Okay, but. who's
Yeah, I
it?
guess. I don't know if it's in her business under her name. I don't know. She's incarcerated and I'm taking care of all her
Okay,
things.
hang on. I didn't
What's up?
swear you in. I don't have your name.
My bad.
And we're going to listen. This is a violation case.
Okay.
So it's similar in a way. We're going to hear from the county, presuming they make a prima facie case, then I'm going to ask you to respond to it, okay? And you're welcome to stand there, but I'm going to swear you in after a little bit. So go ahead. Officer Counselor.
Okay. My name is Chris Counselor. I've been sworn in. I am a code compliance investigator for Martin County. A representative of the Scorpio Summer Season LLC is present. This case concerns the property at 5006 Southeast Capstan Avenue, located within Stuart, Florida, located within Martin County. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Scorpio Summer Seasons LLC, which is a copy of the property appraiser record is County Exhibit 1. On November 27, 2023, I inspected the property. At the time, I observed high grass and trash and debris. At the time I photographed the property, the photographs accurately show what I saw then, and are marked as county's exhibits 2, 3, 4, 5, 6, 5, and 6. Exhibit 2 is the left side of the property as you stand on the road. I have high grass. Exhibit 3, moving down the street in front of the property. Exhibit 4, picture of the driveway. Behind the trash cans, I guess the glare kind of, there's furniture like stored outside, and then I got random pallets off to the right-hand side of the property. Exhibit 5 is on the right side of the property as you're looking at it. And in amongst the two campers, I just have materials stored. I have patches of high grass.
Okay, is this a single-family property?
Yes, sir. Then Exhibit 6 is, I got things in the bushes, again, patches of high grass and miscellaneous materials just stored in and amongst the RVs and vehicles. Based upon the investigation, I issued a notice of violation to Scorpio Summer Season LLC on February 27, 2024, marked as County Exhibit 7. I noticed the following Martin County Code, Section 67.201B, nuisance declared trash and debris, and Section 67.201A for weeds and high grass. In the notice of violation, the respondent was given until March 12, 2024 to correct the violations and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on May 22, 2024, as marked as County Exhibit 8. The return receipt was not received, so on June 7, 2024, I posted the property. A photo of the posting and the affidavit of posting are marked at County Exhibits 9 and 10. 9 is my posting on the front door. And Exhibit 10 will be my affidavit of posting. No call or letter from the property owner was received in time allowed. Therefore, I went to the property again on June 18, 2024, and saw that the cited violations had not been corrected. At the time I photographed the property, the photographs accurately show what I saw then, and they are marked as County Exhibits 11, 12, 13, 14, and 15. 11, the grass on this side of the property has been cut.
Okay.
Exhibit 12, I still have patches on the right-hand side of the property, in between the vehicles and around the campers that's still high. Exhibit 13, I still have materials in the bushes. Exhibit 14, still have pallets and miscellaneous materials. And Exhibit 15, I still have the materials, and back by the red chairs, I still have patches of high grass. So they're cutting it, they're just not cutting the entire property at one time. I request that all county's exhibits be received in evidence. Based upon the testimony and the evidence, I request that the respondent Scorpio Summer Season LLC be ordered to comply with the cited provisions of the Martin County Code by July 31st, 2024. If not compliance, but then be required to pay a fine in the amount of $100 per day per violation until the violations are corrected. The county has incurred the cost of $575 conducting the investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. All right. Sir, if you'll raise your right hand, do you swear or affirm testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
And your full name?
Eric Bruin.
And Mr. Bruin, what is your relationship to?
Sally Ann Frasco is my mom. I'm also her power of attorney. I have that paperwork if you'd like it.
Okay.
But I do need it back. It's my only copy.
Okay.
So I can give you that, though.
All right. Well, let me just look at that. And we can make a copy of it.
Perfect. Thank you. Sounds like I gotta check the mail a little more.
Sounds like it. Do you reside on the property or no?
I don't normally, but being with my mom being incarcerated, I have been living there. And I've been kind of trying to keep everything afloat, but it's been a little bit hard lately just because I'm not used to it.
Let me just take a look at this first.
Absolutely.
Okay. All right, that's acceptable, and if we can just get a copy of that, that would be great. Thanks. I'm actually going to accept that, unless the county's got any objection, I'm going to accept that into evidence
Yeah, we have no objection.
as respondents one. Okay, so what do you need to tell me, other than the fact that you've heard the county's evidence? Any objection to any of that?
Absolutely not. You guys are 100% correct. Grass needs to be mowed, things gotta be moved, can't have trash in the yard. I will say 110%, I have been struggling, and it's not you guys' problem. I've been a little depressed lately. You know, my mom and my sister are actually both incarcerated. Out of our 3 family, I'm the only one still standing. So with that being said, I have been struggling. I did not cut the grass for 3 months, and until your letter, I still probably wasn't going to do it until you put it on the door. So thanks for the kick in the ass, excuse my mouth.
So, without objection, I'm going to accept into evidence the county's exhibits 1 through 15.
Absolutely.
All right, unless you've got something else to tell me, I'm going to find that a violation does exist on the property.
I did actually mow everything at one point in time. I did with a weed eater, everything. The pieces of high grass that you're still seeing out by the trailer back there, that is less than a foot. I brought it all the way down. I will say that because I did read the whole thing. I'm actually going home to mow again today because it's a weekly affair apparently.
Well, it'll be during the summer.
Yeah, I'm not really used to that. Normally, I grew up in Jupiter with a landscaping service, so I'm very much not used to this. I didn't know as far as trash and debris, what you guys were exactly talking about. I figured it was most of the stuff. I do have one question. Can I use one of those blocks that's in front of that pallet there to prop the boat up on, and I will get rid of the pallet?
Yes,
Okay.
yes, and with some of the materials that's there, it's not so much that it's trash, it's just if it just gets organized and stacked neatly instead of
Correct.
laying in the bushes and stuff.
Got you.
That would be also,
Yeah, I mean, as long as we have a clear understanding of what needs to be done, I will get it done, 125%.
Okay.
the only real question is the piece of furniture that's in the driveway.
I argue with my mom about that one all the time. She
Hang
claims
on,
it's for her
hang
plant.
on just a second. Let me just stop you. As you know, it's not up to me to direct how you're going to comply, and I
Correct.
really don't want you at this juncture to try and negotiate that out
Oh, absolutely not.
on the floor. So what I'm going to do is I am finding you in violation, and I'm going to give you until the end of July 31st, 2024, to come into compliance. If you don't come into compliance by that time, then I'm going to fine you in the amount of $100 per violation per day. There are 2. There's trash and there's weeds and undergrowth. So
Okay,
tall grass and trash, each are separate.
absolutely.
All right. And
Repeat the date for me.
yes, July 31st, 2024, which means that starting on August 1st, there would be a fine if you're not in compliance. And compliance means not just doing the work that's required, but it also means having it inspected by the county. And so it's your obligation to contact Officer Counselor and make sure that gets resolved. I am further going to award costs in the amount of $575, which is the normal cost for this hearing, to be paid to the county at the conclusion of this hearing. So when you get the order, you can basically arrange for payment at that point.
Okay.
Okay. And I think that's it. I wish you good luck, and sorry for your family situation, but
No
hopefully
worries.
it,
It's not you guys' issue.
yeah, well, hopefully it resolves.
Yeah, hopefully. Thank you so much for all you
Okay.
guys' time.
All righty.
Contact me.
Very nice to meet you.
Thank you.
Can I give you my phone number?
Yes.
561 768 8189.
Okay.
Don't forget your power of attorney. Thank you.
Okay.
And
Okay.
clean everything up and I'll call you, and if you see anything else, I'll just continually.
Okay, sir.
Good luck, Mr. Brune.
Thank you so much.
Thank you.
Have a good one, guys.
All right, next case is BNF 2023-110599. Jerry L. Owens, Jr. And whenever you're ready.
My name is Chris Counselor. I've been sworn in, Code Compliance Investigator for Martin County. The respondent, Jerry L. Owens Jr., is not present. This case concerns the property at 4985 Southeast Capstan Avenue, located within Stuart, Florida, located within Martin County. According to the official records of the property appraiser, the property owner is Jerry L. Owens Jr. A copy of the property appraiser's record is County Exhibit 1.
Got it?
On November 27, 2023, I inspected the property. At the time, I observed high grass and a damaged fence. At the time I photographed the property, the photographs actually show what I saw then and is marked as County Exhibits 2, 3, 4, and 5. Exhibit 2 is the front of the property. I got a damaged fence and grass, high grass. Exhibit 3, just a picture of the mailbox verifying the address. Exhibit 4, I got weeds along the fence, missing pickets, damaged fence. And Exhibit 5, more pictures of the grass and damaged fence.
Okay.
Based upon the investigation, I issued a notice of violation to Jerry L. Owens on February 28, 2024, and marked as County Exhibit 6. When the notice of violation went out, the grass had been cut, so the only violation still existing upon the notice of violation would be the damaged fence. So that was the only section indicated in the letter, which was Section 21.99 accessory structures for the damaged fence.
Okay.
In the notice of violation, the respondent was given until March 20th, 2024. To correct the violation, was informed of the need to contact Martin County Code Enforcement upon doing so. And that would be County Exhibit 6.
All right.
My signature. Compliance was not achieved, and a notice of hearing was issued by certified mail on May 22nd, 2024, and is marked as County Exhibit 7. It was for the June 19th hearing at 9 a.m.
All right.
The return receipt was not received, so on June 7th, 2024, I posted the property. A photo of the posting and the affidavit of posting are marked as County Exhibits 8 and 9. 8 being a photo of my posting, and Exhibit 9 is my affidavit of posting. No call or letter has been received from the property owner. Therefore, I went to the property again on May 18th and saw that the cited provisions had not been corrected. At the time I photographed the property, the photographs actually show what I saw then, and they are marked as County Exhibits 10, 11, 12, and 13. 10, I still have the damaged fence. 11, fence still damaged. Damaged fence, and more damaged fence.
Okay.
I request that all county exhibits be received into evidence. Based upon the testimony and the evidence, I request that the respondent, Jerry L. Owens Jr., be ordered to comply with the cited provisions of the Martin County Code by July 31st, 2024. If not in compliance, be required to pay a fine in the amount of $100 per day until the violation is corrected. The county has incurred the cost of the amount of $575 conducting this investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, anyone here on behalf of Jerry L. Owens Jr.? Looking out, seeing no one. Without objection, I'll accept into evidence the county's exhibits 1 through 13 in this case. Based upon that evidence and your testimony, I'll find that a violation as charged does exist on the property and order compliance on or before July 31st, 2024, failing which a fine in the amount of $100 per day will accrue. And I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. Okay. Next one.
My final case, yes.
I'm sorry, one more, right?
Yes, yes, sir.
Lara, I guess it's Martha Lara case. It's case ENF 2023-020-120-576. Let me just say that again. ENF 2023-120-576. The respondent is Martha Lara. And again, whenever you're ready.
Okay. My name is Chris Counselor. I've been sworn in. The respondent, Martha Lara, is not present. This case concerns the property at 2651 Southeast Janet Street, located within Stuart, within Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Martha Lara. A copy of the property appraiser record of the ownership of the property is County Exhibit 1. On December 15, 2023, I inspected the property. At the time, I observed fence replaced and there was an AC installed without a permit. At the time I photographed the property, the photographs accurately show what I saw then, and it's marked as County Exhibits 2, 3, and 4. 2, nice new fence. Exhibit 3, the AC in question is over here in the corner, behind the tree. Exhibit 4, both sides of the home have new sections of fence. A Google Street Map view from 2019 showed the old fence, which is County Exhibit 5. So this is basically what the property did look like, showing that this section of fence was replaced and it didn't exist across the driveway, 2019. And Exhibit 6 is the permit history for the property, showing that there's been no recent permit since 2019 for a replacement of a fence. The pre-existing fence was built back in 2003. Based upon the investigation, I issued a notice of violation to Martha Lara on February 7, 2024, which is marked as County Exhibit 7. In the notice of violation, the respondent was cited for Section 105.1 Florida Building Code as adopted by Martin County at Section 21.1 General Ordinances to obtain a permit. At the time, I just cited it for the fence. Even though I had pictures of the AC, I didn't
Okay.
catch it till later. In the notice of violation, the respondent was given until March 7, 2024. To correct the violation, was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, an amended notice of violation. Compliance was not achieved, an amended notice of violation because of an address change was sent with a notice of hearing on June 24, 2024 by certified mail. So basically what happened in the midst of the case, the property appraiser changed. So that's County Exhibit 8 showing that. Exhibit 9 is the amended notice of violation to have the proper address, the updated address. And Exhibit 10 would be the signed NTA, which at the time was going to be the May hearing at 9 a.m.
Okay.
As I was preparing the case and observing the case and the pictures with my supervisor, it was noticed that the AC was also installed without a permit. So, so the case was removed from the May hearing because of additional violations were discovered and time was given. The owner was given more time to correct the additional violations. Compliance was still not achieved, and another amended notice of violation was sent with an amended notice of hearing to include the additional violations by certified mail on June 5th, 2024, marked as County Exhibit 11 and 12. So the reason for this amendment, we had the proper address, but now we included to get a permit for the fence and the AC unit.
All right.
And then the signed NTA, which would be for today's hearing, to include also getting a permit for the AC with the fence. The return receipt was not received, so on June 7, 2024, I posted the property. A photo of the posting and the affidavit of posting are marked as County Exhibits 13 and 14. 13 is my posting. 14 is my affidavit of posting. Sorry.
Okay.
I spoke to the property owner, discussed the violations and what needed to be done to correct them. Then I therefore went to the property again on June 18, 2024, and saw that the cited violations had not been corrected. At the time I photographed the property, the photographs accurately show what I saw then, and it was marked as County Exhibits 15, 16, and 17, with a screenshot of the current permit history for the property as Exhibit 18. So 15, the fence still, they didn't take it down. 16, AC still in place. 17, the fence still up. And Exhibit 18 being, as of yesterday, the permit history shows that no new permits for the AC and our new fence have been applied for. I request that all county's exhibits be received into evidence. Based upon the testimony and the evidence, I request that the respondent, Martha Lauer, be ordered to comply with the cited provisions of the Martin County Code by July 31st, 2024. If not, compliance by then be required to pay a fine in the amount of $100 per day until the violations are corrected. The county has incurred the cost of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
All right, when did you speak to Ms. Lara?
In between the May hearing and today, she stated that she's not, the reason for the address change, she doesn't reside at the property, her brother is. She was hoping that he was going to correct the violations. So I told her what needed to be done, and that was my last contact with her.
All right, okay. Well, anybody here on behalf of Martha Lara? Looking out, seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 18 in this case. Based upon that evidence and your testimony, I'll find that a violation as charged does exist on the property and order compliance on or before July 31st, 2024, failing which a fine in the amount of $100 per day will accrue, and a further award cost in the amount of $575 to be paid to the county at the conclusion of this hearing.
Okay. Thank you, sir.
Thank you. Okay. All right, Ms. Switzer, going to swear you in here. Do you swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right. Let's see. All right, this is case ENF 2023-120062, and the respondent is Casey Levy.
Yes.
And whenever you're ready.
My name is Kelly Switzer, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Casey Levy, is not present. This case concerns the property at 8249 Southeast Eagle Avenue, Hobe Sound, Florida 33455. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Casey Levy. A copy of the property appraiser's record of ownership is County's Exhibit 1. On December 4th, 2023, Nicholas Fisher, a code compliance investigator for Martin County, inspected the property. At that time, he observed an unpermitted addition that was added to the mobile home. At the time, he photographed the property. The photograph accurately shows what he saw then and is marked as County's Exhibits 2 through 4. That's the addition on the one side. This is the other angle. And then 4 is where you can see where they are attached to the mobile home. Based upon the investigation, he issued a notice of violation to Casey Levy on January 12, 2024. In the notice of violation is marked as County's Exhibit 5. In the notice, he cited the following Martin County Code violations: Section 105.1 Florida Building Code, permits when required, incorporated by Section 21.1 General Ordinances Martin County Code. In the notice of violation, the respondent was given until February 12, 2024 to correct the violation and was informed the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on May 21st, 2024, and is marked as County's Exhibit 6. The return receipt was not received, therefore I posted the property and at the Martin County Administrative Building. The posting and the affidavit of posting is marked as County's Exhibits 7 and 8. Posting, my affidavit.
Okay.
A permit application was applied for but has not been approved. A screenshot showing the permit status is marked as County's Exhibit 9. It's waiting on applicant. I went to the property again on June 18th and saw that the cited violation had not been corrected. At that time, I photographed the property. The photograph accurately shows what I saw then as marked as county's exhibits 10 and 11. The structure is still on site. It's just another angle. I request that all the county's exhibits be received into evidence, and based upon the testimony of evidence, I request that the respondent, Casey Levy, be ordered to comply with the cited provisions of the Martin County Code by July 31st, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost of an amount of $575 conducting this investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, anybody here on behalf of Casey Levy? Or Levy? Seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 11 in this case. Based upon that evidence and your testimony, I'll find that a violation as charged does exist on the property and order compliance on or before July 31st, 2024, failing which a fine in the amount of $100 per day will accrue. A further award cost in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
Ma'am. Okay. Well, let's see, you're not Miss Espiat.
I am not, Your Honor.
Playing the part today.
Today I'll be playing the part of her.
But you're going to take the case, right?
Yes,
Is
sir.
that correct? Okay. So this is the D'Agostino case. It's ENF 2024-03-0060-01, Alfred D'Agostino. And if you'll raise your right hand, do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay. Now, let me catch up here. This is 6001. Okay. Whenever you're ready.
Yes, sir. My name is Charles Amberzetti, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Alfred D'Agostino, is not present. This case concerns the property at 2209 Northeast Rustic Way, Jensen Beach, Florida, 34957 in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Alfred D'Agostino. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On March 14th, 2024, Officer Espiat inspected the property. At that time, she observed trash, an inoperable vehicle, and a vehicle abandoned on the county right-of-way. At that time, she photographed the property. The photographs accurately show what she saw then and are marked as County's Exhibits 2, 3, and 4. Exhibit 2. This is the property right here. The cars that were parked on the right-of-way. The trash and debris in the back here.
Okay. The boat on a trailer?
Is a separate property, Your Honor.
Different property?
Yes,
but
sir.
Also in the right-of-way? Okay. Yeah, go ahead.
Okay, Exhibit 3 is another angle of the trucks parked in the right-of-way. And Exhibit 4 trash, all stored within the confines of this driveway. Trash at the front part of the property here. Trash at this angle here.
All right.
At that time, or based upon the investigation, Officer Espia issued a notice of violation to the owner on March 22nd, 2024, marked as County's Exhibit 5. In the notice, she cited the following Martin County Code violations: Section 67.201B, trash nuisance declared, Martin County Code, General Ordinances, Martin County Code. Section 91.33, abandoned in right-of-way, General Ordinances, Martin County Code. And Section 91.34.A, generally inoperable vehicles, General Ordinances, Martin County Code. In the notice of violation, the respondent was given until April 5th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Officer Espia performed a follow-up investigation on April 26, 2024, and saw the property remained in violation. Her follow-up investigation photo is marked as County's Exhibit 6. It's a close-up of the trash and debris all still compacted in the driveway. Because compliance was not achieved, a notice of hearing was issued by certified mail on May 3rd, 2024, and is marked as County's Exhibit 7. The return receipt was not received, therefore, on May 23rd, 2024, Officer Espia posted the property and the Martin County Administration Building. The affidavit of posting is marked as County's Exhibit 8. I personally performed an inspection on the property on June 18th, 2024, and saw that the cited violations had been corrected. The compliance photos are marked as County's Exhibits 9 and 10. Exhibit 9, this is where those trucks were parked and are no longer there. Exhibit 10, he had cleaned up everything that was compacted in the driveway and stored everything neatly. However, based on the history of the property and the number of times code enforcement has cited it for trash, the county is requesting a do not repeat order for trash and debris. A screenshot of the property's history of the code enforcement cases for this property is marked as County's Exhibit 11. I request that all the county's exhibits be received into evidence, and that would conclude my testimony.
Okay. All right, anybody here on behalf of Alfred D'Agostino? Seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 11 in this case, and based upon that evidence and your testimony, I'm going to find that it is appropriate to order the violator not to repeat the violation and to pay costs in the amount of $575 to be paid at the conclusion of this hearing. And for folks at home wondering what happened here, yes.
I don't believe we're charging anything as far as the cost on this one.
Oh, all right. Well, I'm looking at a draft order that it says, order not to repeat violation and to pay costs.
Scrivener's error.
Okay.
I believe in the order it states $0.
Was that somehow negotiated? Or is that just a decision that you all have reached?
Administrative decision, Your Honor.
Okay. All right. Okay. Well, Mr. D'Agostino, if you're watching, you got away good. The county is not asking for costs in this case. However, again, for the folks at home, in order not to repeat a violation, it can occur where someone was in violation and failed to correct it in the time set by the officer for correction and prior to the hearing. So in this case, Mr. D'Agostino did come into compliance prior to the hearing, but not in the time required of him by the code officer. So typically, they would also subject that person to the payment of administrative costs because we had to have the presentation, you had to prepare the case, or Ms. Espiat did most of the work here, but you went out to see it as well. So Mr. D'Agostino does get away without having to pay those costs in this case, but I would say, as a general rule, that's not the situation. So, okay. Very good. And 0 costs. All right. And Ms. Bradley, you're going to start with the Azine case?
Yes, sir.
All right. And if you'll, did I swear you in? I did, all right. Yes, that's right. Mr. Glass. All right, so Ms. Bradley, you're sworn in. This is case number ENF 2024-040784, and the respondent is Kara Alzine. I don't know whether I'm pronouncing that correctly, but
Not sure.
let's see. Okay. All right. Whenever you're ready.
Okay. My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. The respondent, Kara Azine, is not present. This case concerns the property at 1076 Northwest 13th Terrace, Stewart, in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Kara Azine. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On January 17th, 2024, the magistrate signed an order for Section 21.105 swimming pools with a compliance date of February 29th, 2024. A copy of the recorded order is marked as County's Exhibit 2. On May 22nd, 2024, I went to the property and photographed the property. The photographs are marked as County's Exhibit 3. Nope. Maybe. Oh, I see it now. So the pool is green back there still. Has not brought it into compliance.
Okay, and we see that basically through the slats and
Well,
the chair and,
Yeah, I mean, the fence is only like 3
Okay.
feet.
I can see it.
So, but yes. On May 30th, 2024, a notice to abate was sent to Kara Azine for Section 21.105 swimming pools. General Ordinances, Martin County Code. A copy of the signed notice to abate is marked as County's Exhibit 4.
All right.
On June 7th, 2024, an amended notice to abate to add Section 67.201.d abatement, Martin County Code, was mailed by certified mail to Kara Azine and also mailed by first-class mail. A copy of the amended notice to abate is marked as County's Exhibit 5. On June 7th, 2024, I also posted the property with a copy of the amended notice to abate and also photographed the property. The affidavit of posting is, and the photograph of the posting are marked as County's Exhibits 6 and 7. So that's the affidavit of posting. And then that is the actual posting on the property. And Exhibit 8 is a picture of the pool showing that it's still not in compliance. On June 18th, 2024, I did a follow-up inspection and found that the violation still existed on site. The photograph is marked as County's Exhibit 9. So this was yesterday's.
And no change.
No, sir. I request that all the county's exhibits be received into evidence based upon the testimony and evidence. I request that the order to abate the swimming pool be signed and allow the county to cover the pool and place it into compliance. And that concludes my testimony.
Okay. Looking at the attached quitclaim deed, it's in a different name. Do I have the right, maybe I don't have the right deed
It might not be
attached.
the right deed that's attached. Hang on, I'll pull it up for you.
Yeah, the deed says Lot 11, Block 11, Palm Lake Park.
That's because they attached the wrong deed to this.
That's what's attached.
Okay, hold on one second, I'll get it for you.
Just want to make sure we've got the right property and don't want you covering somebody else's pool.
Well, I mean, you know,
Things happen.
this they do. Okay, well, you'll have to make that make sense.
I wonder if, well, what's the date of that deed? What's-
2007, it's the same one you have in your hand.
Yeah, it is. And so,
I'm going to venture the property appraiser has the wrong deed attached. Because that's where I pulled this off of.
I'm not,
Yeah.
let's search Ozine, okay? And just see. There you go. How about that?
So the property appraiser just never updated their,
Yeah, if, maybe just print that.
yeah, I'll put it
And
in.
attach it, because that's the
I'll also.
That's the
send-
later deed.
Yeah, I'll also send it to the property appraiser and find out why it's not.
Well, isn't that interesting? Okay, all right. So anybody here on behalf of Kara Ozine? Seeing no one, And without objection, I'll accept into evidence the county's exhibits 1 through 9 in this case. And based upon that evidence and your testimony, I'll find that it is appropriate for the county to abate this nuisance and to then thereafter hold the property owner responsible for the payment of reasonable cost in this case. And it is so ordered. Okay. Ms. Switzer, you're back.
I am.
All right. Let's see, we've got the Hope Sound Mobile Home Park case.
Yes.
All right, this is case number ENF 2023-100698, and the respondent is Hope Sound Mobile Park Home Park, Inc. Hope Sound Mobile Home Park, Inc. is the respondent. Do I see an order?
Yeah. It's actually, the respondent is MyDoc, if you're looking.
No, that's the next case. This one looks like Irene Artia de Mejeras.
Oh, yes, I'm sorry, that's the,
Yeah, okay, I'm with you.
okay. And before we start, if there's a scrivener's error on the order when you get to it on the signature page, above the respondent's signature, and for the Hope Mobile Zone Park was entered in. So if, when we get to that point, if you wouldn't mind making a correction and putting the actual respondent's name in it. She signed it.
I can just cross it out.
Cross it out, yeah.
It's typed, her name is typed
Yes.
underneath.
Yeah,
I'll just
exactly.
cross out the mobile home park.
Thank you.
Okay, thanks. All right, whenever you're ready, Ms. Switzer.
My name is Kelly Switzer, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Irene Atera de Maharas, is not present. The owner has entered into a stipulated agreement. This case concerns the property at 11090 Southeast Federal Highway, Lot 18, Hope Sound, Florida 33455. This case was not generated from an anonymous complaint. According to the official record of the property appraiser of Martin County, the property owner is Hope Sound Mobile Park, Inc. A copy of the property appraiser's record of ownership is County's Exhibit 1. In this case, the homeowner is being cited, therefore a copy of the certificate of title is marked as County's Exhibit 2.
Okay.
On October 31st, Nicholas Fisher, a code compliance investigator, received a case for an expired permit application for enclosing the screen porch. Upon inspection of the property, he noted that the work was completed. At the time he photographed the property, the photograph accurately shows what he saw then and is marked as County's Exhibits 3 through 5. 3 is the expired letter. 4 is the front view of the mobile home. And so is 5. This section here is where it was added. Based upon the investigation, he issued a notice of violation to the respondent on November 17, 2023. And the notice of violation is marked as County's Exhibit 6. In the notice, he cited the following Martin County Code violations: Section 105.1 Florida Building Code, permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code. In the notice of violation, the respondent was given until December 18, 2023 to correct the violation and was informed the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by Tamika Bush by certified mail on May 20th, 2024, and is marked as County's Exhibit 7. The owner requested an extension, therefore an amended notice of hearing was sent by certified mail on February 1st, 2024 for today's hearing and is marked as County's Exhibit 8.
Hang on just a second.
Sure.
I'm looking at Exhibit 7, which has a February 21st date. I thought you said May, but maybe not.
February 1st, 2024.
Okay, all right. And then it was later amended, okay.
Yes.
Got it.
The return receipt was not received, therefore, the property and the Martin County Administrative Building were posted on May 20th, 2024. The affidavit of posting is marked as, oh, I'm sorry, there's the amended for May
See,
17th.
that's Exhibit 8.
Exhibit 8, yes.
Got it?
The return receipt was not received, therefore, the property and the Martin County Administrative Building were posted on May 20th, 2024. The affidavit of posting is marked as County's Exhibit 9. On May 28, 2024, the owner entered into a stipulated agreement. The owner agreed to come into compliance with the cited provisions of the Martin County Code by September 30th, 2024. If not in compliance by then, be required to pay a fine of $100 for every day that violation continues thereafter. The owner has paid the agreed administrative cost of $350, and at this time, I request that all county's exhibits be received into evidence.
Okay. And what, if anything, was your relationship to the case?
I'm just here to read.
You're presenting it.
Presenting, yes.
All right. And truly, I guess the county attorneys could have just presented it as well. You know what I'm saying? I mean, this officer really had no relationship to it.
Yeah, but it's a stipulation, so it really doesn't
No, it speaks for itself.
speak for itself.
Yeah, I know for the record that Irene Artia de Maharis did sign on behalf of herself, and that Tamika Bush signed, and I recognize that signature on behalf of the county. So I'm going to find that it is appropriate to approve the stipulation and agreed order in this case. And I'm not sure, did I accept into evidence the county's exhibits 1 through 9? If not, I am. Okay, September 30th. All right, good, thank you. And you've got another stip, right?
That's correct.
Okay, this is case number ENF 2023-120176-01, and it's Christian and Michael Mydock are the respondents. And whenever you're ready.
My name is Kelly Switzer, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondents, Christian Mydock and Michael A. Mydock, are not present. The owners have entered into a stipulated agreement. This case concerns a property at 8065 Southeast Mansion Lane, Hobe Sound, Florida, 33455 in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Christian Mydock and Michael A. Mydock. A copy of the property appraiser's record of ownership is County's Exhibit 1. On December 11th, the property was inspected, and at the time, they observed unpermitted bamboo fence divider and patio pavers in the rear of the property. The property was photographed, and the photograph accurately shows what was seen then and is marked as County's Exhibits 2 through 4. It's the front. That's the divider. And those are the pavers. Based upon investigation, a notice of violation was issued to Christian Mydock and Michael A. Mydock on January 24th, 2024, and is marked as County's Exhibit 5. In the notice, cited the following Martin County Code violations: Section 105.1 Florida Building Code, permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code, for the installation of pavers and the bamboo plank fence. In the notice of violation, respondent was given until February 26, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so.
Okay.
Based on a lapse of time, a reinspection was completed by Officer Tamika Bush, and an amended notice of violation was mailed on March 14, 2024, and is marked as County's Exhibit 6. And cited the following Martin County Code violations: Section 105.1 Florida Building Code, permits when required, incorporated by Section 21.1 General Ordinances of the Martin County Code, to apply for a fence permit and for the unpermitted patio slab. The fence has been removed and is no longer in violation. The respondent was given until April 3rd, 2024, in the notice to comply, to comply, and was informed the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on May 6, 2024, and is marked as County's Exhibit 7. The return receipt was not received. The property and the administrative building were posted on May 20th, 2024, and an affidavit of posting is marked as County's Exhibit 8. On June 5th, 2024, the owners, Christian Mydock and Michael Mydock, entered into a stipulated agreement. The owner agrees to come into compliance with the cited provisions of the Martin County Code by September 30th, 2024. If not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The owner has paid the agreed administrative cost of $350, and at this time, I request that all of county's exhibits be received into evidence.
Okay, so anybody here on behalf of the Mydocks, Christian or Michael Mydock? Being no one, I'll accept in evidence the county's exhibits 1 through 8 in this case. Stipulation, as in the prior case, speaks for itself. It is signed by Michael A. Mydock and Christian Mydock on behalf of themselves, and Tamika Bush, whose signature I recognize on behalf of the county. And as stated, the respondents have paid $350 in administrative costs. The date for compliance is September 30th, 2024. Failing which, a fine in the amount of $100 per day accrues. I'm going to find that it's appropriate to enter this order. Okay. All right. Yes, ma'am. Thank you. And then we've got one more thing, and that's minutes of the Martin County Code Enforcement Magistrate hearing for May 15th, 2024. I have reviewed them. They've been submitted by the county staff, and I'm going to go ahead and approve them. Note for the record that the staff recorder, Jillian Collane, has signed them, as has John Colando on behalf of the county. Okay. Anything else to come before us today? No?
Believe not, Your Honor.
All right, so our next hearing is when? It is July 17th. And I will see you all then. Thank you very much. Have a good month. Thank you. We're adjourned.